Very brief things. As Michael said, it's great to be here today. There's a lot of smart people here. Most of us who are in the management business prepare these budgets. I would venture to guess that all of us probably do as well as each other, although we wouldn't say that to our clients. And we really live by three things. You need to be conservative while preparing your budget. You need to look at alternate means to possibly raise income, see if there's any opportunities, as Pat was talking before, about refinancing your debt. You have to protest your taxes, as these gentlemen have been talking about before. And I think the most important thing is you have to be realistic, and you have to get your client to be realistic. And I sit in budget meetings all the time, and we go over repair and maintenance budgets. You know, when a client says, why'd you budget $1,000 for the locksmith or $3,000 for the exterminator? Lower each one by $500. And I say to them, you know, at the end of the day, when you look at your repairs and maintenance budget, if you have a 100-unit building and we take out service contracts for, say, the exterminator, the elevator, and we're left with $30,000 for a 100-unit building, and you think that you can run a building for $30,000, a repair and maintenance budget for $30,000 on a 100-unit building that's 80 years old, you know, you're only fooling yourself. So you need to convince your client that they need to be realistic about what you're doing. Any questions? Yes, sir.
What is the outlook for the star rebate program?
I can answer that. Okay. The star rebate program, that's something that is going to be, I thought it might not be this year, but it's going to be, it's on the table. It's on the table for this budgetary that they're up there now in Albany. So we don't know. I mean, if that takes into effect, it probably won't start till April because the state's financial fiscal year starts at April 1st.
So it's still in effect for this fiscal year, we're still going to get...
Until April 2010. Well, since I'm here, I have a question, okay? Knowing that every borough is different and every building is different, for the year of 2010, this is anybody that's on the panel, what have you seen as your average increases in maintenance?
My buildings?
Well,
Probably in the 5 to 7 range. Part of it is dependent upon what they did last year. So a number of buildings were not prepared for the large tax increase in January and started the year 2 or 3 or 4 or 5% behind. Those buildings typically took a higher increase this year, but I'd say in the 5 to 7% range.
Anybody else want to take a stab?
Yeah, last year we helped a few buildings restructure their debt. In fact, helped build up reserve accounts. So most of those buildings that did that have no maintenance increase. In fact, increased their capital structure substantially. Those that were not affected by a restructuring are looking anywhere from 3 to about 9%, 8 or 9.
Okay, thank you. Anybody else? Come on down.
Yeah, I have a question.
Go ahead.
For the tax guys. What do we think is the tax commission's sort of view on settling past years? We think that they're going to be aggressive. We think they're going to be passive.
Switch it on. There you go.
I won't sing. When you say past years, do you mean the immediate past year, or do you mean going back a number of
No,
years?
so I have a number of buildings that may have 2 or 3
Okay,
years
so
over.
let me just go there. The tax commission only has jurisdiction to do 2 years, which is the current year and 99% of the time the immediate past year. There was some legislation passed a number of years ago which allows them to go back. So for instance, upcoming we're going to have the 2010-11 year. Theoretically, they could make an offer for 2010-11 and also for 2008-9, but you couldn't then get a reduction for 2009-10. Okay, that virtually never happens. The tax commission doesn't like to to do that, so you're talking with the tax commission 2 years. So then the question is, do you get an offer? The only other way to do it is to prosecute the cases in court. And the reality is that in virtually all, for instance, Manhattan co-ops, nobody really wants to try a Manhattan co-op before a judge, unless you have a substantial number of rent-regulated units. The feeling is the Supreme Court reads the election returns. If you know your history with Franklin Roosevelt, I think there's a general feeling that it's unlikely that a Park Avenue or a better building would get a reduction in court. I used to try 2 cases a day in court. I think there are 2 cases a year tried now. So I think the answer is, for the immediate past year, it's going to depend very much on what happens this year. If the Department of Finance, which is the agency that sets the assessments, reduces 2010, 2011, which is going forward, if they reduce that below last year and you have a year pending for last year, I think that will give added pressure to the tax commission to make a reduction. I think Bob is going to agree with me completely that the most important thing about getting reduction is something that none of us have control over, and that is when we walk into the room, who is the hearing officer? The hearing officers are like judges. Some of them are very reasonable, they do their job, and they listen to what you have to say. There are others which basically they just won't make an offer, and particularly some with co-ops and condos just don't understand the process. So it's very much, unfortunately, you can prepare. I know the way our firm does it. I know Bob for a number of years, the way he does it. We make a strong argument, but if you go in there with certain people, that's the luck of the draw, and that's the bad news to tell everybody.
Any more questions?
Yes, oh.
Yes, Dan.
Yeah.
Hi.
I think,
Oh, okay. Anyway, my question now is, you had mentioned, I think David or Erwin mentioned the 5-year plan. When do you bring up to the boards, you're looking at a 3-year projection, the 5-year projection, and the overall common element replacements?
Well, this, to me, should be looked at every year. You should be looking at that every year, and a good time to review your long-term planning is when you're doing your budget. And looking at the components, it's advisable to get the experts, such as engineers, involved to give you a real detailed cost analysis of what it would be to replace and approximately when it would be needing to replace it. Did that get your answer?
Do you want to publish that?
Talking about the SIRA?
yeah, if you could use the,
One of the things that the accountants are required to do is put supplemental information into the audited financial statements on the remaining useful lives of the components of the properties. We have 2 buildings out of 200 that actually put the study in. We recommend that you do not publish it. You can still get a clean audit opinion. In the opinion letter, the attorneys in the industry came up with a fancy word, promulgate. So in the opinion letter, we say that the corporation has not promulgated a study of the remaining useful lives, yada, yada, yada. By publishing this report, you would have to go out and get an engineer every year to do a study of the building, and in the best case, it would be inaccurate. In a worst case, it would be extremely inaccurate. You open yourselves up to liability when you put in the report that the roof has 10 years, and 5 years later, you have an assessment for a roof. But we recommend the boards do the 3 or 5 year study and keep it at the board level and just not promulgate it or publish it in their audit report.
Agreed.
Chris, go.
Agreed.
Yeah, if you could come up to the mic.
The question is for Michael, the machine that you have. My question is, what kind of water you can control the
If you
device?
could, Francis, if you could speak into the mic.
What kind of water you use the device that you have, the machine that you have? Because in the building that I work, we have the, gas boiler instead of water.
The question was, which boilers does it work with? It works Sorry, it works with gas, it works with oil, it works with steam or hot water, and it works on any size. The only ones it does not work with are ones with vacuum systems, which is a very small percentage, or ones that have a modulating burn, which are the very modern ones.
Is another question too, if we consider that MNCI, or it can be a credit or some taxes, you know, for the building purpose, finances.
National Grid, for those customers, is offering a 50% rebate. Otherwise, there are none that we're aware of.
Any other questions?
This is mostly for the certiorari attorneys, and it's just really a curiosity more than anything else. A lot of the buildings that received J51 benefits have settled their certiorari for past years. Now they found that their rent roll is going to be cut by a third or so. Do you anticipate a lot of landlords trying to reopen their certiorari for years that have already been settled based on the fact that the conditions have been changed dramatically?
Number one, I think the estimate of a third is newspaper stories. No, you can't open it up. Bottom line is, you settled it, you're done. You can't. And then the question, of course, is if you had $200,000 worth of income in the year 2007, and then if the world ends and you've got to give back $50,000 in the year 2012, are you cash basis? Are you accrual basis? If you still have open years pending from the back year, what year is it taken against? I'm not optimistic it's going to make much difference. But once the case is settled, that's it. You can't go back. Always things can happen to change, but you can't open up a settlement. Or even if there was a court decision, you can't change it.
Any more questions?
One here. Let me ask the question. I represent the lending community, and what we're trying to do, of course, is to review co-ops and condos so that the borrowers that would come to any particular major bank, I talk to them all, but the issue of the reserves has been something, capital reserves has been, well, some of my gray hairs are now because of that, okay? This promulgation, as it was mentioned, is something that we're finding a hard time because most of the banks are trying to sell their loans to the agencies, Fannie Mae in particular, which has a guideline to say that you need to have in a condo budget 10% capital or replacement for replacement reserves in a budget. And you know, when we don't see that, then we're looking for the reserve analysis. What do you plan on doing? And we're really struggling with this, and we're trying to do things as, well, in my case, we're trying to do it by maybe doing an interview with every property manager that doesn't have the 10% in their budget to see if we do have some reasonable way of determining that there's adequate funds for that condo so that Fannie Mae will be comfortable in terms of buying that loan. And so we appreciate any comments or suggestions, or is there just a way that you can have a budget, you know, for a line item, 10% capital reserves or 10% replacement reserves in there, just to make it a little bit easier, not necessarily for the lenders, but easier for your tenants that are either in the case of condos, the unit owners themselves.
Right.
Thank you.
Right. Well, I guess let me say one thing. In buildings that we manage, and I think Michael is going to talk about this also, but in the 20 years that I've been doing this, and my company manages probably about 80 buildings, I don't have a building, nor have I ever had a building, that set aside money on a monthly basis for a reserve fund. Whether that's good economic planning or poor economic planning is up to somebody else, but typically buildings in New York don't do that. So how that works with what you guys do, and we run into this all the time, is as people try to refinance their end loans, you know, I'm not sure what the answer is.
I think you as the lender, we can't dictate, you know, how you process your loans or underwrite them. But the problem that I have with that, even conceptually, is you have two buildings next door to each other, right? One has a $500,000 reserve fund, one has no reserve fund. The one with the $500,000 reserve fund is just in disrepair, it needs $3 million worth of work, but the building without the reserve fund is pristine. It doesn't need a dollar of work. So, just to arbitrarily say, put 10% aside, no, as Danny said, none of my buildings have it as well, and we manage similar portfolios. I think that the banks or the lending institution, whoever does your underwriting, has to do a little more due diligence. And what you suggest about interviewing the property manager and saying, visit the building, right? You're going to do an appraisal anyway, but unfortunately, the appraisals are just market comps. But, either visiting the property or speaking with the property manager as to what the condition of the building is and overall. We're obviously not going to sign a sworn statement, but maybe give you a little more comfort level with respect to making the loan. I wish I had a magic answer for you, but just to put 10% aside, just for the sake of putting 10% aside, just doesn't make good sense to us.
Michael, did you ask Patrick how he would handle an application that goes to a bank, how he could? Patrick, is there some way that if you were handling an application as a mortgage broker, how you would somehow convey that information?
Well, there's two things here. There's underlying loans. He's talking about loan for. He's an end loan.
Yeah.
So this is for
condo unit owners.
Condo unit owner. Correct.
Yeah.
The building is going to have a big appraisal, and they're going to do an environmental, and they're going to study the whole building.
In fact, for co-ops, it's not so much of an issue because we're able to look at the results of the financial audits and things like that. It's with the condos, and it's really Fannie Mae is dictating to the lenders, and then the lenders are trying to comply with Fannie Mae because no lender wants to make a portfolio loan if they can avoid it. They want to be able to sell that loan. You may have heard that there's been a little bit of an issue with lenders the last couple of years.
Did you want to say something?
No, I think
Okay.
the answer.
Great. Any other questions?
Yeah, I do. I'm Richard Russell. I own a mortgage brokerage firm for the past 20 years. And in concurrence with what he was saying, it's a very strict guideline. The banks simply do not do end loans unless you have 10% of the annual reserve of the annual maintenance in reserves. So when especially on 10-unit walk-up co-ops, none of them, they're self-managed, a lot of them, they have no clue what that even means. Right. So I've had to go, on the Upper West Side, it's particularly rampant, this problem. The way I've gotten around it, these buildings are essentially not financeable as end loans, is by taking the effort of going to the board meetings, explain to them how this works, or having them come up to my office, and eventually you beat the bat against the head and they listen and they do it because they're non-saleable assets, or unless they comply, and or you're going to find a lender that doesn't care and the rates through the roof. So it's just something that has to be dealt with at one point or another, but they're very strict about that.
This is something that's recent now.
It's
They're
within the last
tightening
12
this now.
months. Yeah, and in fact, I called the guy by the name of Pat Conway. I have this guy that works with Fannie Mae, and he used to be the Dime Savings Bank years ago. I'm that old. And I said, Pat, has this? He said it's always been in effect, and a lot of these things have been in effect. But the banks now, Wells Fargo, for example, are now implementing them on this business operating. Maybe you can help me with that. Insurance, that you have to have the insurance policy. It has to equal now the maintenance per year. So that now has been in effect for 10 years. Business operating income, whatever the proper terminology is, and they've never been implementing that either. Now they are. So then you have, in the case of a building on West 23rd Street, there was a $700,000 difference, and they had to increase the maintenance for the end loans to be done. And this was Penmark, and I had to get David, somebody who owns Penmark, to comply that at a board meeting, and they did it. Otherwise, they were non-saleable, non-transferable loans.
I just want to, before we end this with Margie, I just want to bear out what this gentleman has said, what Jerry has said. Hey, you heard what happened with Fannie Mae and Freddie Mac. They went broke. There is new underwriting criteria. There is brand new, especially for condominiums. There was a project that was tested in New York condominiums. Now it's unrolled nationwide. So what's happening is a whole new ball game. What we have done in the past may not be good for the future. You should keep that in mind. And what I find as a problem is not so much the underwriting criteria, but how the lending institutions interpret those criteria. Some are stricter than others. So talk to your banks and find that out because it's a brand new lending game in town. Thank you. And I would, one more question.
One
wanted to ask the certiorari attorneys about fees. Whether, in fact, after deciding on the commission, it's usual to negotiate the fee once you've actually got an award. How often you do that, and to what extent you will negotiate.
They don't negotiate.
The negotiation is appropriate to occur up front.
In the microphone, please. Thank you.
Excuse me. My suggestion is that it's appropriate to negotiate the fees up front before the work is done.
Fee or a commission?
It's a fee. Typically, it would be a contingent fee based on a percentage of the actual tax savings or whatever the arrangement is you make with your attorney. But the time to negotiate that is before you retain the attorney, because at that time you can go to any one of 5 or 6 different firms and make your best judgment.
What's the range?
Depends on the size of the property and then the negotiating skill of the representative of the co-op or of the residential property.
Thank you, thank you. Before I give my closing comment, for the speakers, if you could all wait here, because we're going to have a group shot. But then, if I could ask everyone who is going to want to meet and ask personal questions to the speakers, is to get them in the other room, because we have exhibitors, and that's part of how we finance today. Okay, so we need to get the people in where the exhibitors are, so they keep buying exhibitors, and we can run these fabulous programs. So my final comment is, one, about this, what Dan Woolman had said about, cutting down 300 here and 400 there, and before you know it, the budget, that you can't change anything. You can't really change payroll, you can't change your taxes, you can't change your mortgage, and all these things that are set, and all the little items they want to shave off. Well, every month, when your monthly report comes out, that's what you're going to sweat through, because you're going to be over budget on a multitude of line items. They're all small line items, but the aggregate on the page, it looks like all these categories, you're over budget, when it's really only a couple $100 here or there. So every month, your report card looks bad. And so if they want to cut something, have them cut something that is an elective for the board. So then if they want to add it during the year, it can be in the minutes and it can be added to the budget. But all your little operating expenses, you want that solid, so your report card every month, they're not beating you up, because they're not going to remember the budget meeting where you said one thing or another. The other thing is this is getting the staff involved. We want to have monthly staff meetings. We want to bring in the operating expenses to the staff, because every company in corporate America, the staff knows how well the company is doing. And there's nothing secretive about the expenses for the building. So we want the staff to see that the heating costs have come down, the electricity has come down, and so forth. The water, because every company in corporate America, the staff knows how well the company is doing. And there's nothing secretive about the expenses for the building. So we want the staff to see that the heating costs have come down, the electricity has come down, and so forth. The water bills are less. And so they can get that excitement, and you're getting buy-in, because just having them be reactive from a memo or a directive and not really understand. And it is the staff that's going to make so much of that happen. And since the staff is almost 50% of your budget, and certainly 30% of your budget, it's a waste if you don't use them proactively. Okay? Now, for the rest of the day, everyone's on a different payment plan here, because we've got a lot of things going on. For those of you who know you're staying for lunch, we're back here at 1 o'clock, and we will hear from Peter Finn and Howard Rothschild from the RAB, and they're going to talk about the coming contract expiration and any other staff issues that you have. And we will also have them talk about if you need to reduce staff for financial reasons. We will discuss that, because right now is a moment in time. The union is signing off on almost every single one that they get. In another couple of months, in another year, they may not be so fast to do that. So if you've been pondering that for your building, now is the time to get that approved. Okay? So back here at 1 o'clock, but everybody is invited to the open bar and the refreshments in the other room. So thank you very much, and we'll see you later.
Giving, and I do, on behalf of NYARM, wish everybody here a happy holiday for the rest of the year. Unfortunately, I've been very busy since the election day. It seems that government and the Bloomberg administration is trying to push through its agenda on things that's going to affect us. This morning we had a seminar on budgets. Although this will not have an immediate impact on our budgets for next year, it definitely will have an impact on our budgets in the future. If you recall, last Earth Day, the mayor, along with Speaker Quinn, announced a group of bills called the Green Bills. One of them, specifically 967A, would require buildings to have an energy audit once every 10 years, and in that audit, if it says that you need a new piece of equipment and the payback, a simple payback, was 7 years or less, you had to do it. Without any question, you had to do it. So we met with the office several times and said, hey, now is not the time to do that. And how can you, why don't you give us some incentives to do it? City's answer was, we have no money. And I looked at them, what do you think we have? So it was quiet during the summer during the Bloomberg campaign. And about 2 days right after the election, I got summoned back to the office, the mayor's office of long-term planning and sustainability. And they said to us, hey, we changed the plan. We understand your needs. You can't do capital improvements. What we'll do instead, you still have to go out and get an audit, and it still has to be put in there what your capital needs may be. But you don't have to do them. But what you do have to do is whatever the recommendations are about efficiency of your equipment, you have to do. Now, and then about 4 years later, you have to have what they call a retro commissioning person, which can be the same thing as an auditor, come out. Now, the problem is they want a licensed professional designer, okay, which are licensed engineers or architects. And I said, hey, half of them don't know what energy savings is all about. Why can't you use people like NYSERDA has approved partners to do these energy audits at a much cheaper rate than an engineer or an architect? And they said, no, we want someone's license on the line. So they refused on that point. I brought up other points on this long list of what they say you have to do, like if you have a temporary repair on your plant equipment, by the time you come and do this the retro commissioning report, you got to make that temporary repair permanent. And I said, hey, through construction inefficiencies and defects, you have to do permanent, and it's impossible to make sometimes a temporary repair permanent. They said, okay. And then there's all this paperwork, onerous paperwork. And they said, oh, well, you got to do it. This is part of it. And they wanted all this paperwork, energy report, and their retrofitting commissioning report all go to the building department, be on file like Local Law 11. So I said, well, I may buy into this a little bit because it's at least, who, as a building owner, whether you're a board, whether you own your property, does not want their plant equipment run efficiently, because the more efficient, the more money you save. So I said, I still have some problems, but maybe I could buy into the concept. One of the things I asked, though, was, hey, I keep on hearing from the beginning of this year that DEP wants to ban number 4 and number 6 oil. And they said to me, we don't know of any legislation that will ban number 4 and number 6 oil. So, much to my surprise, I get a call, and it says, hey, they want to regulate the banning of number 4 and number 6 oil. So once I heard that, and I said, hey, we're being piled on because they're using the back door to get what they originally wanted with the capital needs, with a regulatory thing that says, hey, you got to change your boiler equipment out. I said, hey, how can this be? I said, number 4 and number 6 will wreak havoc among property owners in this city. So I have to say that NYARM is part of a coalition that consists of real estate management associations, oil companies, the unions, as part of this great group. And the problem is that it's all coming from on top, from the administration. As you all know, 2 years ago, Mayor Bloomberg unveiled its 2030 plan. The 2030 plan, part of it, has to do with environmental. And it's been quoted that this year and the upcoming year, he wants to concentrate on his environmental part of the plan. What the problem is that this 967A that they passed, yesterday they had a briefing with the city council. They want to pass this in the month of December because they already had one hearing, so there's no need to have another hearing. So they want to pass this during this session in December, because once they go to January, the whole ball of wax starts all over again with the new council. They got to do new hearings, and they don't want to do this, all right? And number 4 and number 6 oil, there's really been from the top down driven, because that's, if you read his 2030 plan, that's what he wants to do. Now, according to the last regulation that I saw, when they talk about banning 4 and 6 oil, it all depends on your C of O. The last 2 numbers on your C of O indicates to you when your boiler or burner has been replaced. So in 70 or earlier boiler installations, you got to have it done by 2012. And then the next 15 years by 2015, and the next 4 years by 2018, on and on and on until you get to 05, which is 2005, which is, you got to wait till 27. So it is a phase-in, but they will not issue any more if you want to go and put in a new burner, boiler, no more permits for 4 and 6 oil. And so you say to yourself, I got gas, what do I got to worry? You do. Why? Because we in New York City do not have the infrastructure to deliver the amount of gas that will be required in this city without an increase in cost in that gas. And it's a very, very important issue where you have on one side, the environmentalists are saying we have to lessen the carbon footprint, and what is going to cost us as property owners, management of co-ops, condos, and what we have to tell them. So I will tell you a couple of things. And I just got an email today, about an hour ago, from my good friend Marianne Rothman, the Council of New York Cooperatives, that Channel 2 has just contacted her. There was a report by the Environmental Defense Fund that says number 6 oil is hazardous to the welfare of the people in this country. They are now doing a report, and once that comes on, and I wonder how that came out, all right? I wonder. So when that comes out, that's going to have the populace saying, hey, we got to do that, and I see the mayor's strategy, where he was once open. I can see this next 4 years is going to be very secretive. What I do urge of all of you to have your buildings contact your city council person and tell them that 967A is an unfunded mandate brought upon the city of New York, and at this particular time, as they're raising real estate taxes, they're raising water and sewer, and the other costs that are being rose, this is not the time to do an unfunded mandate to us at this particular juncture of this economy. So I urge you all to report back to your buildings and urge them to contact your local city council, because before you know it, you're going to turn your back and it's going to become, it passes the city council, and I can assure you, I can guarantee Mayor Bloomberg will sign it. Okay. Thank you. I'm sorry, you know, it's the end of the year, it's a holiday, but, you know, they got me busy. What can I tell you? 4 and 6. 4 and 6 oil. They want to ban both, 4 and 6. Did you want to say something, Margie, or you waiting? Okay. All right, listen. I just want to, you know, for those of you who do not know, I'm sure everybody here knows, recently we lost a friend, a confidant, someone who fought for us, someone who has been, you know, had the respect of the Union 32BJ, someone who I personally thought the world of, and he was just a great servant and a great advocate of us as management and owners of the building. Jim Berg unfortunately passed away a couple of weeks ago. And I just want to say that it's with NYARM gives our greatest respect for him, and that was great sorrow for his wife, his family, and the family of the RAB who is here today to make a speech. And I just want to acknowledge that. With this, I will turn it over to Margie Russell, the Executive Director, who has a few announcements.
Thank you, Greg. Well, we're going to get right into our main speakers, but as you all know, how we operate at NYARM, we eat right through while the speakers are talking, so don't feel that you have to hold back on enjoying your meal. But one of the things I do ask for is for total focus and silence while we have our speakers, and it's often difficult because we're so happy to be here and be with our friends and chat, but there's plenty of time for that afterwards. And talking about afterwards, for those of you who are NYARM members in good standing, we hope that you will join us at the election that's going to happen immediately hereafter for the open seats on the board. If you are a member in good standing and you have to leave early, please see me so we can make sure that we have your ballot before you leave. But we would hope that you could join us for the election. At this point, I would like to introduce our two representatives from the Realty Advisory Board, Howard Rothschild and Peter Finn. Welcome. And we can't wait to hear what you have to share with us today. Thank you.
Thank you, Margie, for those kind words. Good afternoon. My name is Howard Rothschild. As many of you probably know by now, Jim Berg passed away on November 18th, and from that moment on, the industry has generated tremendous support. Various real estate groups, including NYARM, placed obituaries in the New York Times remembering Jim. Many individuals and management companies have reached out to the RAB to express their condolences regarding Jim, and we appreciate these expressions of sympathy. One of the lasting legacies of Jim is that he left the industry and the union on a proper course regarding labor relations. Jim used to enjoy attending these lunches and interacting with Margie, Greg, and the rest of the NYARM group, and I'm sure he's looking down now, smiling about today's great turnout. Before moving on, I'd like to get a sense by the show of hands, how many people in the room today were involved in the industry during the 2006 apartment building negotiation? Thank you. Also, by show of hands, how many people here today were involved in building management during the strike of 1991? Okay. Until you have lived through a strike in an apartment house, it is hard to imagine all of the issues that need to be addressed during a labor stoppage. In 2006, the industry was undergoing a recovery of the healthcare fund crisis. That issue has been resolved, and I am happy to report that the fund is running in the black and actually built up a surplus of over 6-month reserves of operating capital. The other good news is that the other associated welfare funds, including the legal fund, training fund, and scholarship funds, are also on budget, and I don't expect major increases over current contributions. Now the bad news. The 32BJ pension fund, like virtually every other defined benefit pension fund in the country, has experienced shortfalls in anticipated revenues from investments. The good news is that the fund didn't have any money invested with Bernie Madoff. But the bad news is that it did have investments in a diversified portfolio, including the stock market. This fund has partially recovered along with the market in general in the last 5 months, but over the last year and a half experienced shortfalls. The Pension Protection Act, passed by the United States Congress, generally identified funds as being in the green, yellow, or red zone. The Pension Protection Act requirements are currently under review by the Congress, and the trustees and their advisors of our fund are carefully monitoring any changes in the requirements and proposed changes in the law. If the PPA is changed, the period of time to implement funding changes would be greatly extended and thus likely relieve certain contribution requirements. In any event, it is clear that the pension fund needs increased contributions. This issue will undoubtedly be at the forefront in the upcoming negotiation. In the meantime, the fund actuaries have been directed to produce various economic models as to future funding requirements so that the industry is prepared. Given the long-standing bargaining relationship between the parties, I don't anticipate major changes in the current agreement. Wage increases are always a cornerstone in collective bargaining. The union will argue that employees deserve to be paid more, since they have been affected by the events in the last few years. However, that has to be balanced by the economic realities of 2009. Taxes increases, water and sewer increases, the Court of Appeals decision in the Stuytown Peter Cooper Village case, a negative inflation rate overall, and rising unemployment are among many items that directly affect our industry. Margie also asked me to speak about reductions in force. As probably most of you know, that under the current collective bargaining agreement, employers are allowed to decrease their work staff. However, they have to comply with the written requirements in the contract. First, before you implement the reduction, you need to send at least a written notice to the union at least 4 weeks in advance, giving them the reasons for the reduction. In the contract itself, there are about a half a dozen different reasons that allow employers to reduce. Those reasons really all come down to one general concept, and that is that if you're going to implement the reduction in force, you need to show the same implementation of a reduction of work. So if you're going to implement the reduction of, let's say, a full-time 40-hour-a-week employee, you're going to need to show on paper in advance to the union what 40 hours of work you're eliminating. So let me give you first a very easy one. You have a service car operator that works 40 hours a week, and all he does is go all day long up and down in the service car. That service car is automated. No one else is going to do that work. If someone wants to go up and down in the elevator, they're going to have to actually push the button themselves. That's a perfectly legitimate reduction. That's something that I wouldn't anticipate any problem with. There are other reductions that become more complicated. And I'm sure you and I can think of dozens of scenarios. If this is something that you want to implement, my suggestion to you is give the RAB a call. That's what we're there for. We'd rather get involved on the front end and give you advice and counsel than to wait to the back end till something was done incorrectly. And then you'll hear some RAB lawyers say, you shoulda, you woulda, you coulda, and you don't need to hear that. So let us help you out from the beginning. In the meantime, I would stress that as we approach April, agents and owners carefully prepare their buildings and residents. The RAB, as always, will publish our preparedness manual, and we are available to speak to groups concerning the upcoming negotiation and how to best implement a preparedness plan. We can be contacted directly if you have any questions. I look forward to working with all of you, the backbone of the industry, regarding not only the upcoming negotiation, but also for many years to come in the future. Jim used to say that negotiation is all about the union wanting more and management offering less more. At the end of the day, I can assure you that the RAB will seek a fair and reasonable settlement that embodies Jim's views and values. Thank you.
Okay, questions? And I'll start with the first question. Preparation, of course, is the best defense against a strike.
Right.
And so this year we should prepare even more because of all the many reasons that are in front of us. So what should the first thing we should do earlier?
Well, we're in the process of, at the RAB, of doing several things. First, we're in the process of naming a residential negotiation committee. Certainly, I've always been of the view that not one person or one group has a monopoly of good ideas of how things should be done. So if you want to have any input, either to myself, the RAB, the committee, send me an email, send me a note, call me on the phone. We're always looking for good ideas. Third, we're going to be coming out with the preparedness manual probably sometime, I'm going to guess, in January or February. Fourth, we have prepared this year a PowerPoint presentation that we can give out to any group that you want. When I say give out, I mean we're not going to give it. We'll come and meet with you and so on. So that's what we're doing. Insofar as your buildings, you know, I'm looking around the room. There are a lot of experienced people here. I guess my single bit of advice is you can't wait to the last minute to do things. This has to be an organized plan by management or by the boards of the buildings, because it cannot be implemented overnight. If you call me up on April 19th or April 20th, by the way, the contract expires midnight of April 20th into April 21st. So if you call me up on April 20th, well, first of all, I'll probably be at the negotiating table because these things are never settled early. But you'll get someone from the RAB and you'll say, well, I called every security company in town and no one has guards left. And that's because you waited to the last minute. So I guess in real estate, the three key words are location, location, location. When it comes to this, the three words are preparation, preparation, preparation. And so we'll send out the booklet. You'll get it. You'll get it very early. It'll give you plenty of lead time, but don't ignore it. Don't do something that I sometimes do, which is put it on the corner of my desk and I'll get to it whenever. You need to get to it sooner than later. And if you do that, if you are prepared, not only will you see that and your residents will see that, but your building employees will see that and the union will see that. And what I've always found is the more prepared you are, the less likely something disastrous will happen, because the other side will recognize it. So it will help you, it'll help your residents, and hopefully it'll avoid, any potential problems.
Another question now, as far as you had said that the building employees need to see that we're prepared. Now, is it so awful if a property manager sincerely tells their building employees, we're preparing for a strike, save your money, because if the strike happens, it could go for 3 weeks. Do we want to let them know that we care about them and we want them to save their money? At the same time, it's putting the fear in them, and they might translate that back to the union. We don't want to strike because, that kind of interplay, I know it's tricky, but...
Under the... I'd be careful what you say to your employees at times like that. The National Labor Relations Act governs the interaction of employers and employees and unions. And while you might be saying that in a humanistic way, potentially, I think it could be argued that that type of statement might be construed to be coercive or a threat. And while we generally have a good relationship with 32BJ, and they're considering the size of the industry, there aren't that many unfair labor practice charges that get filed in this industry with the NLRB. I think at least theoretically it could be an issue. So I would say be careful, make sure you know who your audience is, because you may have certain relationships with employees where they may look at that as being, word of advice to their benefit, and you may have other groups of employees that may take that as being a threat. So I would be careful about stuff like that. Sure.
Hi, my name is Lisa. I'm from Esquire Management, and I'm dealing with two issues with a 32BJ building. One, this year the board is going back and forth about giving them a holiday bonus, so I want to know if it's mandatory that they have to give it or not. And the second part of my question is they're way over budget, and we're looking to cut costs, and we had a meeting last week, and they asked me, they have a super, a porter, and a handyman, and they want to let go of the handyman, and they're all 40-hour-a-week, 32BJ employees. So that's my question.
So I'll answer the questions in order. There's nothing in the bargaining agreement that mandates that you give holiday bonuses. I would, in that regard, I'd be somewhat careful, though. You don't want to get into an issue of it being discriminatory. So I think, you should set whatever policy you want to set. But don't, if you have 5 employees in the building and they, and they're all in one type of group, and you have someone else who's not in that group, and you give it to the 4 and you don't give it to the 1.
No, they want to
you
give
may end
none.
Up, that's better. That's fine. With regard to the second question, is this a co-op or a condo?
It's a co-op. It's 124 units.
Okay. So does the handyman only perform handyman-type work?
Basically, handyman work, and they feel he's not necessary anymore, and they want to...
So, in all likelihood, the rules of the co-op, the bylaws, when the co-op originally, the plan was declared with the Attorney General, probably indicates that shareholders are responsible for work inside their apartments. And probably as a vestige from the rental days, there was probably a handyman that got carried over after the conversion. And probably as an accommodation to the residents, the handyman continued to perform the same type of work that he performed before converted to co-op. So what you should essentially do is make sure that the handyman's work is segregated from the other work in the building. Get a survey, get an understanding of exactly what is the handyman doing for 40 hours a week. You know, he's going into apartments, he's fixing toilets, he's leaky washers, whatever he's doing.
But to eliminate his job completely, could they do that as a
The answer
board?
is yes, but you need to do your homework first. First, you need to find out exactly what he's doing for 40 hours a week. Okay? Because what you don't want to happen is for you simply to implement this thing and then you find out, wait a second, my handyman did 20 hours a week of porter work and 20 hours a week of handyman work. Because then what the union will say is, now your porter has to pick up the other 20 hours of porter work that was previously done by the handyman. So you need to know what that work is.
Okay.
Concretize it, figure out, okay, he does this takes 5 hours, this takes 9 hours, etc. It adds up to 40, it's all handyman work. If it's not all handyman work, segregate it. Take away the porter work, give him 40 hours of handyman work, wait a sufficient period of time, meaning a few months,
Okay.
then eliminate that work, okay?
Okay.
You want to make it clean. You don't want carryover from, it's half of this and, three quarters of that and so on. It becomes complicated, and then you'll get a parade of building employees coming to the office of the contract arbitrator all saying, I'm all overburdened with work now because I have my 40 hours and his 20 hours. So if you do your homework at the front end, it'll make things a lot easier at the back end. And believe it or not, the union has been surprisingly reasonable when it's done correctly, which is not the way they always were. This is sort of a changeover in 32BJ.
That's good to know. Thank you very much.
You're welcome.
Okay. Howard, one distinction on that. So we have financial hardship, and then we have the work is not going to be there anymore. The
Right.
work that's not going to be there, the elevator operator. But financial hardship means 3 guys might have to do the work of 4. And so how do you present that?
In truth, all of these things come down to financial hardship. If the building wasn't hurting, if they weren't trying to make budget, if they had other ways of raising revenue to keep an additional employee on, it would never come to this to begin with. So it always comes back to financial hardship. But you can't rely on that alone. You really need to rely on the fact that you're eliminating a similar amount of worker hours that results in a reduction in work. Okay.
Thank you.
Okay.
Thank you. Thank you. Now, that closes our presentation for today, and again, immediately after this meeting, we're having the election. But right now, and forgive me because there's been board members coming in, going out, and so I've lost track of who's here and who's not, but I just want to announce who is at the dais and who is here as a board member. So Robert Molina, who was the anchor CPA, from Ziedman, Lacauer, and Prezand, thank you for being the anchor for this morning's fabulous budget program. Wiggins Lindor, advisory board member from Rosenwalk Tank. Peter Lair from Caled Management, board member. Erwin Cohen from Aid Michael Tyler, board member. Greg Carlson, president from Carlson Realty. And as we know, Howard Rothschild and Peter Finn from RAB. Jeff Hauer from Wentworth Cooper Square, advisory board member. Nelson Davis, Jad Baggs, board member. Angel Velasquez from SecureCom, advisory board member. And then we have in the crowd Bill Jabali from Bay Ridge Fuel, Aggressive Heating. Bill. At his table is Rochelle Captan, President Emeritus. Rochelle, you're over there in the corner. Okay, thrilled that you're here. Okay, Rochelle. Okay. We have Ed Morse, board member from Amaretta Hess, or Hess Corp. Okay, Hess Corporation. Okay. All right. Did I forget anyone from this side of the room? Okay. No. Who we also have distinguished. We have Mike McGowan, last year's Resident Manager of the Year. Mike McGowan, raise your hand. Thank you. Okay. We have this year's Resident Manager of the Year, Arthur Kearney from Gumley Haft. Arthur, please raise your hand. We have the former leader of the Green Team, Lance Cole from Schwab House. Lance, raise your hand. Okay. I don't think I forgot anyone. Is there any? James Rauscher, former Resident Manager of the Year with Gumley Haft. James. I think we have it. I think we have it. Okay. Well, thank you all for being here. This was excellent. And so, because unfortunately Tavern on the Green is going through some reorganizing, we will be back here. We're just not going to be back here in January and February. And we wish them well. We're coming back, guys. We're coming back. But January and February, we will be at the Hotel Pennsylvania, which you all know because that's where our trade show is every September. So we will be there in January and February. So watch for that. It's also very convenient because those are the cold snow days, and you can come right out of the train and the subway and scuttle right into the Hotel Pennsylvania. So we will see you there. Enjoy your lunch, and again, immediately here after, we will have our election. If you are a member in good standing and you're leaving, please see me so we can get your ballot. Thank you. Thank you.